Hey guys, welcome back to our 2024 real estate market forecast. I am super excited. We were talking about this earlier, we're not even sure. 5 years, 6 years?
Sounds about right.
Okay, Barry Lee O'Connor with Barry Lee O'Connor and Associates.
Correct.
In Riverside, 35 years plus.
Correct.
I think you and I have been doing business
for 35
most
years.
of those 35 years. I was on your website earlier today, and over 70,000 UDs. That's a lot of business, my friend. That's a lot.
It's a lot of with Fannie Mae, Freddie Mac, and HUD, and then a lot of with your company somewhat, and a lot of property management companies and individual landlords. And
well, I think that's how we got to know each other, because my mom was in the property management business, but I was, at that time, was doing mostly Fannie and Freddie and everybody else.
What year was that, do you think?
Well, it was in the early
90s?
Well, yeah, 92, 93.
Right.
I think it's so funny because that's, well, let me finish the introductions, and then we'll jump right back into that. So, 35 years in the business. Again, we've worked together for most of that. Now, again, getting back to our real estate market forecast, we've done two pieces of the market forecast. And it probably has been 6 or 7 years that you first came in, because the first 6 or 7 years I did the forecast, and this is year 14, I didn't do any what I call industry stuff. It was all economic stuff. I'd have an economist come in and we'd say, what's going on and where are we going?
Right.
And then 6 or 7 years ago, I said, I want to have some industry people come in. So Barry, my eviction attorney, is what I consider the industry side of what we are part of our market forecast. So our audience is landlords, tenants. We do property management, a bunch of realtors that are attending. Many of them kind of want to get a little bit of both. My landlords, for example, and the realtors, they want the economic side. But they also, hey, I'm an investor, I'm a landlord, what's going on with these crazy eviction laws that we're dealing with? So when I started doing the industry folks, which is why I've asked you many, many years to come join us, I'm like, okay, Barry checks that box. Not that eviction law is a sexy topic, but it's probably one of the most important things that as an investor, if you don't know what the heck you're doing, especially today, oh my gosh, what kind of trouble can we get in? So let's get back to how we started dating. So I'm thinking the Fannie Freddie first cycle was probably 1992-ish. And that's probably how you and I first met. We were probably in the Moreno Valley Courthouse there on Heacock.
Correct.
And
13800 Heacock.
Yeah, that's right. And I mean, just for the banks alone, you probably did tens of thousands of foreclosures of evictions.
After foreclosure.
Post foreclosure.
Correct.
Wow.
And the thing is I think at some point in time we were dealing with savings and loan. There was a savings and loan collapse.
Yep.
I'm not sure. I think that was a little bit before that.
Probably so. Wow, you're really going back, because that was probably 91-ish.
Right.
And the reason I remember that is my father, I was going to say my father and I, but the truth be told, it was my father bought a Realty World franchise. Realty World was owned in part by Lincoln Savings and Loan.
Ooh.
And that Lincoln's one of the savings and loans got taken over by the RTC.
Right.
So you were doing those too.
Correct. So that had to be late 80s, early 90s, somewhere in there.
Yeah. Yeah, well, I came in Moreno Valley in 88, and we did the Realty World in 89 or 90.
Yeah, so it had to be right in there.
Wow. Okay, so we're not doing a lot of post-foreclosure evictions anymore. So you've been doing mostly traditional,
Yeah, but
clientele.
everything seems to be a lot more complicated. For the first 35 years, or 33 years, I practiced law, 32 years, I never did a consultation.
Yep.
I've gone to doing consultations all the time, because I got to hear the backstory of what's going on with the property, what the cause is, why they can evict them. If the tenant just owes rent, usually that's not necessary, unless there's been other problems with maybe a major leak in the house and maybe a mold issue, and then I got to hear it. But so we've been doing half-hour consultations, and having to prepare special notices and review the notices, review the paperwork, the I spend most of my time in the office, and I don't go to court like I used to. I used to spend every morning and every afternoon in court.
Yep.
Now I spend most of my time in the office.
Well, because you got to figure out what mistakes have been made. Isn't that really partially the whole consultation part?
Yeah, you got to figure out that, but you got to look. Used to be, I'd say, tell the staff or somebody, we'll just do a 60-day notice.
Right.
Now you have to prove your case basically on paper. Before you even start your case, you have to prove your case on the notice.
Right.
You know, on the 3-day notice to pay or quit, that was pretty simple, but if you can't just give a 60-day notice anymore, you just can't give a 30-day notice anymore, unless it is exempt from the Tenant Protection Act. And then if somebody says, well, my property is exempt, then you got to look at it and see if it's really exempt.
They're really exempt.
And one is, did they give the proper notice back in 2021, I think it was.
No, it was before that.
Or
Wasn't it
2020.
Well, the law came in effect in January 2020. So the
is
notice needed to be in 2019, correct?
Yeah, and it had to be completed by 2020, I think, first of 2020. I think they gave you to June or something.
Okay, so let's set the stage, because you and I live this stuff, or you live it more than I do, but I'm sure we might have lost a little bit of our audience. So, and if I'm wrong, correct me. So, best I can tell, pre-COVID, now, and keeping in mind,
2019,
but the rules really changed. I mean, we didn't know COVID was going to hit us in the face in early 2020, but the rules changed, the Tenant Protection Act and those rules changed. So before that, is it safe to say that
we could give a 60-day notice or a 30-day notice for any reason as long as it wasn't an illegal reason?
Right. So it was a simpler, faster process.
Correct. And I trusted my landlords because I knew most of them, and I knew they weren't discriminating, and you know, so we didn't worry about it, you know. And then we'd find out when the answer came in, if they filed an answer. They didn't file an answer, we'd take a default, and so we didn't have to worry about it.
Okay. So Barry, in my world, there's pre-Tenant Protection Act, which I kind of think of as COVID. Okay. Even though that was happening prior to COVID actually coming into play in early 2020. And then there's everything since then. So how have things changed? It was so much simpler before, and now it's not. So what's the differences in paperwork, filings, all of it?
Well, it's all very complicated and compared to what it used to be. And I hate to say this, but I have 8 friends that quit doing this because they're attorneys. Because it is so difficult to do, and I can't tell you how many clients that I have that are actually attorneys that send work to me. And they even used to do evictions themselves. Right. And the notices, you just can't give a 30-day notice. It used to be at one time we could give a 30-day notice to everybody for any reason, or as long as it wasn't an illegal reason.
Right.
An illegal reason was
discriminatory type.
Correct. Right. Correct. And or they reported you to the police for something, or a code enforcement. So now you're going to evict them.
Right. Retaliatory.
Retaliatory. Right. So you couldn't do that then. Now, the first step they did is they changed the 30-day notice to a 60-day notice, whereby if somebody lives in the property more than a year, you have to give a 60-day notice. That still holds true.
Yep.
Okay. Now, you either have to have served the notice that the property is exempt from the Tenant Protection Act back in 2020, or whenever exactly it was, or if you've entered into a contract since I think it was like 2023, you have to have language in there addressing the Tenant Protection Act.
Yep.
The CAR form has that language, but the CAR form's not clear.
Right.
The box has to be checked that the property is exempt from Tenant Protection Act.
Right. And you don't like the CAR forms, basically.
No, not for that.
Right.
And to be exempt from the Tenant Protection Act, you have to own the property either as like a corporation, or a individual, or a trust, or an LLC. And it can't be really owned by a corporation. And it's got to be a single-family residence. Yep. So and unless it's a duplex and you live in the duplex, and then it can be exempt. So basically, all multiple units in California now are subject to the Tenant Protection Act.
But isn't that in part, I don't want to go down this rabbit hole because it's not most of our audience, but isn't that kind of in part what this whole thing was about? They wanted to target the large-scale multi-family apartment buildings and kind of put the crosshairs on them.
But they shot the mom and pops.
Well,
because most of mom and pops don't know they have a contract. They were somebody that's had a tenant for 15 years or 10 years. Now they want to get rid of them. And I tell them, you can't get rid of them unless you have cause. So let's talk about what are you going to do with this property. In most cases, it's they're going to sell the property. Well, if they're going to sell the property, that's fine. But if it's subject to the Tenant Protection Act, they have to waive the last month's rent. Or they have to give the tenants that money up front. I always say waive the last month's rent.
Waive last month,
And give them a 60-day notice. And now, in 2024, they changed the law. You have to state who's going to live in that property.
You have to state at the sale? How do you know that?
No, not at the sale. I'm sorry. I apologize.
We skipped ahead.
I skipped ahead. There's a second. If you're going to move into the property or have a relative move into the property,
my kid's going to move in.
You got to state who's going to live in that property. And if another cause that you could get somebody out for is you have to do a substantial remodel. But now they've changed the law on the substantial remodel. You have to have the permits pulled already before you give the notice, or you have to have a contract written up with what work's going to be done by a contractor and a signed contract.
How do you decide that the word substantial? It's not just carpet and paint. I can't say I'm going to carpet and paint.
Substantial means you're going to pull permits. Somebody has to be out of the property. You can't do it within 30 days. They're going to have to be out more than 30 days. And then the big thing is what is the work that's going to be done? If you're going to tear up the floors, you're going to, you're going to rip out the electrical, rip out the plumbing and stuff. You're going to have permits for that anyways. So you got to look at the overall project, what's being done, and the people that, if for some reason you don't do this project, or you don't move your relatives in, now you have to notify the tenants. You have to have their forwarding address, notify them, and give them the opportunity to move back in.
Do you have to give them the opportunity to move back in even after the substantial remodel at the higher rate?
No, if you don't do the substantial remodel or you don't move into the property, then you have to.
Then you must.
Yeah.
But you got to figure most people are doing that. I mean, I just wonder, we don't have to get into crazy examples, but how many people are out there trying to game that system? It's like, hey, I want to get this tenant out. I'm going to tell them I'm going to do a substantial remodel.
Well, that's why I do these consultations, because a lot of my clients want to game the system.
They want to game it.
They want to game it. They just want these people gone because they're a pain in the butt. And you can't evict somebody for that. Now, if they're doing major things, they shot somebody in there or they're dealing drugs or something, that supposedly could be a nuisance and you could do a 3-day notice to quit.
Are you sure shooting somebody is a nuisance, Barry?
Well, it could be.
Okay.
It depends on who they shot.
Yeah, it could. All right. Just
if it was some of my relatives, probably it's not a nuisance.
Yeah, that'd be okay. They'd be in and out pretty quickly and back in, and you probably have to buy them new carpeting or something.
Right.
Wow, I can't believe it went there. But okay, so let's back up a little bit. So you were talking about the consultations, and you're doing, and I know that I've experienced this with you because we're doing them, and as the end user of your product, not so much as a landlord, but as a property manager. One thing that I've noticed with my team is, man, you talk about crossing T's and dotting I's. So I mentioned this a little earlier. The consultation, the way I view your consultation is maybe a little different than the way you view it. You just want to make sure everything is in place. I look at it as, okay, what kind of mistakes have we made as a property management company, okay? You've got me terrified to do any sort of notice. We used to do them all the time. We would do a 3-day, we would do a 30-day, we would do a 60, we would do all those without you, so to speak. We'd follow the rules, we'd check the boxes, and we'd say, all right, Barry, it's time to move forward with an unlawful detainer. We'd send it over, and 99% of the time, okay, everything looks good. Occasionally we did recently, you probably didn't get involved in this, we did one. We did all the paperwork in advance, we sent it over to you, we had the wrong zip code. It was a typo on the zip code. And I'm not sure how far we went. I think we ended up getting to a clerk somewhere, kicked it out. We burned 60 days. Yeah. So your consultations now, it's to hear the story. Is your landlord trying to game the system?
It's mainly to figure out a game plan, how we really can get rid of this tenant. What cause we have to get rid of this tenant. What the intent of the landlord is. and what kind of notice we're going to have to do. You know, whether it's going to be a 3-day notice to perform. And you can't, we used to be able to do a 3-day notice to perform or quit. Now we can't even do that. We have to do a 3-day notice to perform.
Okay.
Then if they make the mistake again, then we have to do a 3-day notice to quit. One of the biggest things I see all the time is unauthorized tenants. Well, it's how do you prove unauthorized tenants? All they have to do is say, well, we're just visiting.
Right.
You know, basically you got to prove they've been there 3 weeks.
Right, how are you going to do that?
How are you going to do that unless you have cameras in it? It's a multi-unit building.
Right.
You know, and you know the
And even
neighbor,
if you have the cameras in there,
and it's going to be a hassle. And you know the neighbors aren't going to come in and testify.
Yep.
You know, and you can't, whatever the neighbors say, that's hearsay. It's not a court statement.
Let's talk timeline a little bit, because I know we've got some landlords out there, some investors who have not gone through this, or maybe they have gone through this, but they haven't gone through it in a while. Okay, so back in the good old days, this is pre-2020, pre-2019, I come to you, I've got a just cause, or I've got somebody who hasn't paid their rent. We do a 3-day, from the time you get the file to the time we end up in front of the commissioner, to the time we've got a writ, to the time we've got a lockout. What was that under a best case, worst case scenario?
The best case kind of, Bill Garrett claims he evicted somebody twice in 1 month, but from 2 different properties. But, you know, we shoot all the time in BS, and Bill covers my practice when I'm not there, but I still don't quite understand that or believe that. But
okay, let's do real world.
Real world, I think that if we gave a 3-day notice on January 3rd, we could have the tenant locked out by January 30th.
Okay.
And so a month.
Okay.
Complete case.
Perfect world.
Perfect world.
Yep.
Now it takes 1 month to get the writ issued from the clerk.
Okay.
Takes 1 month for the sheriff to do the lockout.
Okay, so we have 2 months.
We got 2 months there. It takes 3 months basically to get to the point where we either have a judgment either by default or by trial.
Yep.
And then if we had to give a 60, so that's 5 months.
Yep.
Then if we had to give a 60-day notice, you got 2 months on top of that. That's 7 months.
Yep.
That's 7 months that a landlord is not going to be able to take rent from a tenant. That's 7 months that a landlord is going to lose rent on before he gets his property back to spend the time and money to fix it up, to either sell it or to re-rent it.
Right. Okay. So I'm going to recast that time. I'm going to play attorney now. Okay. So let's get to that 7 month. So I'm doing a 60-day notice. So there's 2 months. Tenant doesn't perform. Now I'm coming to you and getting the UD. Now that 90-day window, you in my mind you kind of got a little backwards. So that 90-day window from that, I've already 2 months in on the 60-day notice. You go ahead and you file the UD 90 days before we ultimately get in front of the judge.
Correct.
Okay, so now it's our 5 month under that scenario. Now in the old days, we get in front of the judge, we're successful. We basically get our judgment for possession, and maybe we get judgment for some money, and then we would get that writ of possession.
Correct.
And we would get it right there.
Correct.
Okay,
we could get it in the courtroom.
In the courtroom,
right.
or that afternoon.
Correct.
Okay? So from the time we now are in the court with 90 days, 60 days to do the notice, 90 days to get in front of the judge, we're now successful in front of the judge to get the little piece of paper that says, hey, you've got a writ of possession, no longer at the court, up to 30 days.
Correct.
And that's just 100% just paper pushing or lack thereof.
That's if the court doesn't see something that they think, even though it may not be, is wrong on that writ, then they send it back to you, then you've got to submit it again. You know, that's if it's 100% correct.
Okay, so now we've got it, and then in the old days, that we'd get that over to the sheriff, and the sheriff would do a lockout in a week to 10 days.
Yeah, I would drive it from Moreno Valley to downtown Riverside on Orange Street. I would hand it to the sheriff.
And now that process is taking another 30 days as well.
Correct.
So there's your 7 months.
Correct.
And that's if everything goes perfect.
Correct. And that's if they don't file bankruptcy, they don't ask for a jury trial, and anything along those lines. And that's the other problem is that, you know, there's people out there, there's they're not really nonprofits like they claim to be, because they're attorneys that end up making money by requesting jury trials. They
Right.
basically extort the landlords for the cost of the jury trial, and they get additional time for the tenants. They
Yep.
keep the money they extorted, and the tenants get additional time. That's why I quit doing evictions in LA, because that's LA County, because that's the normal procedure in LA County. It hasn't quite gotten here in San Bernardino and Riverside County that much.
Well, but maybe I'm thinking something different, and I haven't gone to many of these as I used to, but it's been a while, and I don't mean like a year or two ago. It seems like for the last 10 years, whenever we would end up at a UD, whether it was you or one of your associates, there's always a tenant advocate.
Correct.
That's in the court.
Those were legitimate tenant advocates, or for legal aid.
Okay.
And a lot of times they would actually be a benefit, because they would explain reality to the tenants that, hey, look, you're going to get about 2 more weeks, and we can make this with the records sealed, which now the records are sealed anyways, where the tenant's eviction's not going to show up on the record.
How long has that been?
Couple years. Since COVID, pretty much.
Problematic, though.
Yeah, I know.
I'm a landlord, and I'm trying to screen a tenant, and I can't see if there's a UD that's been.
Correct.
Okay, it's funny. I have my cue cards here. And are we getting anywhere close to normal? And not only are we not getting anywhere close, it's never going back.
No, it's never going back, and it's the worst step each time. But they did give us one thing this year.
Okay.
And it's amazing. Senate Bill 602, which is actually the criminal law code, 602 for trespass. Now what property managers and owners should do, if they get a property back and it's sitting empty, they need to take and put no trespassing signs up on it, take pictures of it, and then report it that their property, and register it with the police department or the sheriff, whoever has jurisdiction over that property, that the property is vacant. And then once you've done that and you've filed that form with the proper police agency, then if somebody breaks into that property...
Somebody other than anybody.
Anybody breaks into the property, then they'll be arrested for trespassers.
Right.
As trespassers. If you don't do that, and you probably remember this from the Fannie Mae cases, that if somebody gets in there, you got to go through the whole damn eviction process again.
Well, they pull up a piece of toilet paper that said, I have a lease.
I have a lease or whatever. But this does protect the landlord from that.
Okay, so once the property's vacant, whether that's post-eviction or the tenant's abandoned it, or it's just vacant. So what's the statute again? This is
it's 602.
602
of the criminal code,
I should know
it's
this.
602 of the Senate. It's the Senate bill.
The Senate bill
that was passed January 1st of 2024. It went into effect.
Okay.
It was passed last year and in effect January.
Okay, well, gosh, I hope my team back at the office knows this.
I've talked to them about it before.
So it's now vacant. We've basically filed this with the local municipality,
and the other thing is,
sheriff or whatever.
The other thing is, I left out. You probably should take pictures to prove that you had the no trespassing sign, and they'll be dated on the property. Of course, the sheriff, when we do a lockout, puts a no trespassing sign, but I would put some other signs on it too.
Heck, we've been doing that because now we're talking Fannie Mae, Freddie Mac days. I used to carry those things around in my cars by the ream. I'd be posting those no trespassing signs on there all day long. Okay, so this is just our new world. It's not going to necessarily get any better, although I guess the 602 is somewhat of an improvement. So from your perspective, and again, I'm not kidding. I mean, we're a professional property management company, and I don't want to say we're afraid to file a 3-day or a 30-day or a 60-day or a notice to cure covenant or something like that. But I got to tell you, depending upon what it is, it's like, man, is this something we need to send over to Barry's office?
I looked at three-day notices. They weren't your company. I don't remember if they were individuals. So I think one of them was a property management company. They were all wrong. There was something wrong with them. Yeah. And I looked at a couple that were right, but I think I saw 3 that were bad today. Right. And everything is so technical, and the clerk's office, and which I think is wrong, and they need to be kind of reeled in, and I've done this before when I used to go to court all the time, is that I feel they're practicing law without a license. They should not be determining whether the paperwork that the attorney files...
You're about the clerks of the court.
correct.
Yeah.
Whether it's correct or not correct,
Right.
it's up to the judge to make that decision, not them.
Right. And but that's happening.
That's happening all the time, and they're looking for reasons to reject.
Yeah.
And when you have a paperwork rejected now, it ends up costing the landlord another month and lost rent,
Yeah.
whether it's valid or not valid.
Well, another month. I mean, heck, we made a
You know-
mistake last year, and you had the pleasure of informing our office that we had made a mistake. As a matter of fact, I think we made a couple of mistakes, and we ultimately ended up ended up reimbursing them because that's how we are. But we ended up costing, I think, 60 days of lost rent for our landlord, and we fell on the sword and said our mistake. And because it was our mistake, we ended up basically eating. We ended up eating and paying it.
And the rents aren't like they used to be, and that's what people don't understand. If the rent's $3,000 a month, if a piece of paper is sitting in the clerk's office, that's costing the landlord $100 a day.
Yep. Yeah.
$100 a day.
Yeah. Well, let's talk about rents. Okay, so, and this we may segue into an area that's, well, it's certainly outside of the landlord-tenant law or the eviction side, but I certainly have opinions on this. Okay, so we had the, basically what I call statewide rent control.
Correct.
In the state of California, which
and most people didn't realize it was passed.
Well, yeah, well, because, and again, I might be wrong, but my memory is there was a discussion about passing it, and then there was a proposition that was put out that was voted down.
Correct.
By the California people.
Correct.
Said no, we don't want that. California legislature came back and said, well, fair enough, we're gonna do it anyway.
Tenant Protection Act.
Tenant Protection Act. So this is the deal. So if you're not familiar with how this works, I'm going to oversimplify it. You're going to correct me. I now own a rental. I'm in Cali again, statewide rent control. So you're my tenant. It's now 12 months into the lease. I have the ability to raise your rent 5% plus the CPI during that window of time, not to exceed a total of 10%. Unless
it's exempt from the Tenant Protection Act,
okay.
Then you can raise it more.
Okay.
But if you raise it more than the 10%, then you have to give a 90-day notice.
Okay. And so we got that. All right. So for argument, but I'm going to go a little different direction on this. So going back to when this was all coming into play, which I believe was January 1st, 2020.
Correct.
When the 5% plus the CPI
Correct.
not to exceed a total of 10%. So you had landlords who were paying attention, scrambling.
Correct. I did that.
Scrambling.
Yeah, I
right?
had what I call a come to Jesus meeting with some
Okay.
of my tenants because
Right.
the rent was so low.
Correct.
And I told them, hey, we got to work out something that's fair for both of us.
Yep.
Because I felt that this was coming, it was just a matter of time. You know, I was probably doing this in 2016, 2017,
Right.
or whatever.
But you're an attorney. You follow these things. You know. So I'm your average. You mentioned earlier, just kind of your mom and pop landlord. Maybe they don't have a property management company.
Correct.
Or maybe they had a property management company that didn't quite understand the details. So now I've got a tenant. I've tried to, which we have a lot of landlords. They're just solid people.
Correct.
The tenant's having a hard time. Maybe they just had a baby. Something's going on. They have the ability to raise the rent.
But they don't.
But they don't.
I'm the same boat.
They don't. Like, hey, you know what? You guys are doing okay. I'm going to give you a break. Well, you can't do that anymore.
No.
Because if I don't do that, I'm never going to catch up.
Right.
Right?
Correct.
We have dozens and dozens of those properties that we either have managed for a while or they've been brought into our
And that's why I
management.
have people come to me and they want to get rid of the tenant. They want the tenant to move out. And I tell them, you can't do that unless you're going to do a substantial remodel of the property.
But a lot of those people, I'm assuming many of those people, the reason they want to get the tenant out because they're $1,000 or they're 10, 20, 30% below market in rent.
Yeah.
Well, that's kind of your fault as a landlord.
Correct.
Because you were not paying attention back in 2019.
But what I tell them is, hey, look, if you consistently raise the rent to 10% for 3 years, compounded, that's about, at the end of 3 years, 34% increase in rent.
Right.
So you gotta, like you said, you gotta do the 10%.
Right. And if you don't, you'll never catch up.
Never catch up.
Now, I'm going to go in a different direction. So we're in an inflationary environment. I mean, you can't. I mean, my gosh, anything to do with real estate or just alternative.
Go to Home Depot. You know, your prices of everything
Home
have
Depot.
doubled.
Go to McDonald's for
Yeah,
God's
well,
sakes. You know?
I'm saying that relates to real property.
okay.
You go in there, anything you want to fix or repair or whatever.
All of it.
All of it. It's doubled.
It is. But okay, now let's bring it back to rents, because again, this is in
Rents
theory.
haven't doubled.
Huh?
Rents have not doubled.
Well, they have not doubled, but the rents have certainly increased. I believe that the rents have increased at a pace higher than they would have if the Tenant Protection Act wasn't in place.
Definitely.
Right?
Yeah, because you can't take the increase you need. Inflation is more than 10%.
Okay, but the irony of that is that's not what the legislature intended.
No.
I believe the legislature intended on trying to basically keep rents lower.
In the same token, the legislature made unintended consequences when it comes to single-family homes. It doesn't make economical sense to have a single-family home as a rental now, because of the return on investment. The average single-family home has got to be $500,000, you know,
Yeah.
and in order to cover it, you got to, you know, $500,000, and then on top of that, if you got $3,000 a month, that's $36,000 a year. But you got your property taxes, you got your insurance line. Insurance is going sky high. You got your maintenance on. You end up making 3 or 4% on your money.
Yeah. Okay. Well, Barry and I, before our session, and I don't want to put words in your mouth, but like, hey, man, you just want me to say it like it is. Some of it might be negative. I'm like, yeah, of course, if some of it's negative. And I think we segued immediately into what the state of California has done that has made it very unattractive to be a landlord, an investor in California. And, well, I guess you just kind of said it. And the vast majority of the properties that we have under management are single-family rentals.
Right.
And it's difficult to argue with what you just said.
Well, I feel stupid because I have a lot of single-family houses, but in the same token, I can't afford to sell them because most of them are all paid for, and I'm going to really eat it on property taxes. The other alternative is to do a 1031 exchange, but I don't want to have more tenants, especially in California.
Yeah.
So landlords are caught in a bad situation.
Yeah. So you would 1031 into Florida or Texas or
whatever, but I don't want
outside of California, Nevada.
But I don't want to own out-of-state property either.
Right.
I don't want to be. You can't. My theory has always been every property I own was either close to where I live, close to where I work, or close to a court that I went to all the time.
Right.
So I could keep an eye on the property.
Well, you're an active, investor and want to keep an eye on your stuff, and that's just your comfort level. It's funny because Bruce Norris, legend in the Inland Empire.
Yeah, he went to Florida.
Well, yeah, and he started liquidating all of his stuff in California many years ago, and he went to Florida, and he's now basically building build-to-rent projects. He's selling some stuff as well, but basically building.
But argumentally, he left California too soon.
He did, but you can't time everything, right?
Right.
But having said that, actually, Bruce is doing a thing. June 8th, for you Bruce Norris fans, he's doing it's a version of his market timing event. It's going to be a little bit more, but he's going to be in town June 8th, Riverside Convention Center, and it'd be interesting to see his thoughts. I've attended most of his. It's funny you said, because as you were saying it, I was thinking, he probably left a little early. But who would have guessed that you'd see a 20% appreciation in 2020, COVID, 20% appreciation of property values in 2021, the second year of COVID. And, we saw the pullback, but then we've seen the back trench. I don't know. Is anybody that good?
No. Nobody has a crystal ball that I know of.
I think he's done fine in Florida, though. And quite honestly, he doesn't have the challenges that you and I are discussing.
No, he doesn't. Not as far as evictions go. It's a lot easier in Florida. It's a lot easier in Texas. It's a lot easier in Arizona. And I have clients that have gone to Tennessee and clients that have gone to North Carolina.
Right.
I have a lot of clients that have left the state because of the environment. How many landlords can afford to give away 6 months worth of rent, especially ones that don't own their homes free and clear because they have their mortgage payment besides the taxes, insurance, and maintenance.
Yeah. Well, mine certainly can't. Most of the stuff that we manage at Cobalt Property Management are single families. But again, most of mine, we have managed hundreds and hundreds and hundreds of units. Most of our landlords, however, are not necessarily landlords by choice.
Correct.
Meaning somebody passed away, or there was a divorce, or there was a job transfer, and they're not really sophisticated investor type landlords, and they're not necessarily in a financial position. Certainly, forget about losing 4, 5, 6 months worth of rent.
Right.
I mean, heck, some of them struggle to have to replace a hot water heater.
And that's another reason why I have gone to doing the consultations, because I don't want my clients to be mad at me 2 months down the road because I don't have the tenants out.
Right.
I want them to know what they're getting into,
Right.
how much time it's going to cost, and how much it's going to cost them. And I feel guilty about all this, but blame it on the state. There's nothing we can do, and that's why I tell all of them, I'm a landlord too. I'm in the same boat you are.
Yep.
And most of my friends that did this type of law, they weren't landlords, and I don't really think that they can really relate to how a tenant or a landlord feels toward its tenants, and when they have to go through the eviction process.
Yep. Okay, let's talk about this. Since we're talking about the statutes and the laws, the changes in relation to the amount of security deposits that a landlord can now require to be held as part of a lease.
Okay. They changed that in January 1st, 2024, pretty much. Or I guess it went April 1st. But you can have 1 month's rent only. It used to be, if it was a furnished house, you could go 2 months.
Yep.
But what I'm more concerned about is they left it open and it's ambiguous. I don't think that, I want to find out the hard way that I was wrong.
Okay.
But, pet deposits.
Right.
They say you cannot have a security deposit over 1 month's rent.
Right.
So I believe you cannot have if the house rented for $2,000, you can have a $2,000 security deposit, but you can't add another $500 pet deposit on top of it.
$2,000 max, or whatever the amount of the rent is.
Correct.
And you don't want to test that. You don't want to test. Nobody wants to test any of these things.
No.
Yeah. Okay. So maximum 1 month, no pet deposits. But you can charge pet rent.
I don't know.
I'm hearing that.
I don't know.
Are we going to test that?
No.
You don't want to be my. You don't want to be my attorney to test that one.
No. But the thing is with that, it's so easy for them to say this is a service animal.
Right.
Yeah. All they got to do is
going on forever. That's been.
Yeah, but you can't charge a deposit or on a security deposit on a service animal.
Correct.
So argumentatively, if you can't charge the security deposit, you probably can't charge rent for a security animal.
Oh, couldn't charge rent for a service animal.
Correct.
Yeah. Well, that's not necessarily a Tenant Protection Act thing. We've had that.
Right.
And I don't want to be a hard ass when it comes to these things.
No.
But it's like, really? I mean, that 300-pound, Saint Bernard is your emotional support.
Yeah, but
animal.
I've had landlords want to push it, and and I had one property management company that didn't even really refuse the dog, but trying to think of what it's called, fair housing claimed that they did. Yeah. They ended up settling and paying $75,000.
As a settlement through fair housing because the landlord was deemed discriminatory.
Yeah, even though this person didn't really apply and say apply with their dog.
Yeah.
Yeah. So it's a real scary area, when you have animals involved.
Yeah.
Yeah, I think it's another no-win for a landlord.
It is, and it's funny, you just kind of triggered something with me on we've never had these. My mom started the property management side of our property management business back in 1990, I think it was. And, you periodically would have somebody complain or something like that. But I always felt we run a solid company, we do the right thing.
Complain about what?
Well, but, they got denied for the wrong reason or,
right.
Whatever it happened to be. But in the last 3-4 years, we've had 2 complaints that were taken to, and I'm going to have the wrong agency. It's a governmental agency. The state of California, it's like an employment and housing or something like that.
Correct.
A discriminatory case.
Correct.
Discriminatory.
Right.
And I'm like, really? Us? And we went through the process. We were basically we were exonerated, if you will, in both of those cases. But it was a regulatory government process that was coming through with state of California logos on these legal documents. It was terrifying. Like, really? And again, it was kind of another one of those things you sit back and actually one of them, my landlord, ended up not pleading guilty, that's not a right way to put it, but agreed to basically go take some training. because the landlord had done some things that the tenant was accusing them, even though we were managing the property. Landlords, let us manage, don't get involved in the process. But yeah, that's a whole other thing. We've had 2 of those in the last 3 years, and haven't had any of them in the prior 32 years.
Right.
Okay, so what's new with the screening process? We talked about this briefly. What can we not do that we could do before?
You can't say somebody, if they're on housing or something or get substance, you can't deny them access to the your property by saying that they're unqualified.
Based upon income.
Yeah, let me read the exact language so I'm not.
Hey, if you didn't read at least one document during our interview, this wouldn't be us. So Barry's come prepared.
Starting January 1st, 2024, landlords must consider a housing applicant's receipt of government rent subsidy, including, for example, Section 8 Housing Choice Voucher, when assessing the applicant's income and ability to pay rent. In addition, the housing applicants who receive a governmental rent subsidy must be allowed to provide an alternative credit report as means of proving their ability to pay rent. Now, this is what they mean by an alternative credit reporting, not an actual agency, but includes example of public benefit payments, pay records, and bank statements.
An alternative credit report. Okay, so I wasn't going to go there, but you're trying to think of something that I heard recently through the California Association of Realtors and their legislative advocates up there. So I get the Section 8 thing, and honestly, I think most landlords and most property managers, by the landlords, excuse me, housing providers, because we're not using the landlord term anymore. Most housing providers and property managers these days, we've never had a problem renting to somebody with a housing voucher. I mean. Have there been people that have abused that? I'm sure, of course there have. But, I always go back to the fallback to say, we've had a lot of tenants over the years that legitimately qualified for a Section 8 voucher or Housing Authority voucher, and we rented to them all day long. Okay, and frankly, for years, we would say, there's your voucher, you've got, that's income. We're good with that. But this credit report thing I'm hearing of. Now, the alternative credit, now is that saying, but does that apply only to a housing tenant or does that apply to anybody? As far as, we've been running credit reports forever, and I'm hearing these rumblings that we're not going to be able to do that in the future, or we're going to have to take a standardized credit report that the tenant can come to me and say, hey, go to this website, or here's a copy of a credit report that I already ran. Is that what that says?
This says landlords must consider a housing applicant's receipt. So this addresses housing applicants only.
Okay. And housing applicants, you're talking housing authority, which in
some sort of governmental
Section 8,
or another program, where they have a voucher or something.
Yeah.
Here's what scares me about this and makes me mad about this. And I look back, and some of the original tenants I had were on housing. At that point in time, and again, I'm what's that, 30, that's almost 50 years ago. Originally, housing was fairer to the landlords. If a tenant moved out and didn't pay the rent, they would cover that.
Yep.
If a tenant destroyed the place, they would cover that.
That was a long time ago, though.
That's a long time ago.
Right.
But again, I don't think it's fair to landlords if they're going to accept somebody on housing, because somebody on housing doesn't have deep pockets.
Right.
You can't go after them in court. You can't do a wage garnishment because most of them aren't in court, and there's no assets to attack.
Right.
So I really think that is not fair to landlords. Not that we can do anything about it.
But I don't know if this is the case anymore, but the one thing that I thought was legitimate and I liked about the housing is, okay, we wouldn't necessarily get a credit or some sort of a payment if the house was torn up after they moved out, but they would know that. And it was always my understanding.
They would get kicked off housing.
They would get kicked off the program.
Correct.
Right. Or if somebody abused it, they did an inspection, hey, you got people living on the property that aren't supposed to be there, they would get kicked off the program, which was how it should be, and it seemed like there were some checks and balances there.
And again, you got to go through the eviction process on them if there's a problem, just like anybody else.
Yep. Okay. Wow, Barry. Have we said it all? Have we covered it, or we haven't even started? I feel like we haven't even started, but
well, let me look at my notes.
You have notes,
but I think we pretty much did. And
Well, as you're skimming your notes, I'll give you a
Okay.
chance. Oh, you found one, or did
No,
we cover it?
no, we covered it.
Okay, well, this is the deal. I don't do commercials as part of our market forecast.
Yeah.
But you're about as close to a commercial or an endorsement that I would do with anybody that is part of this particular
Appreciate
annual
that.
event. But it's easy because part of the reason we do this is because we do a lot of property management, and we do have a lot of landlords that are watching this, and we do have a lot of investors and a lot of real estate agents. And for 30 plus years, whenever this comes up, I'm like, there's one guy. It's Barry O'Connor.
Yeah.
And sometimes I probably said this behind your back more than once or twice. Man, he's so damn conservative. But I mean, isn't that kind of what you want when you're dealing with an attorney? And
I want to see my clients protected, and I feel that my job is to educate and protect.
Right.
And that's what I try to do. And I hate doing these consultations, but the state of California has forced me to do it.
Right.
And that's the only way I feel that I can practice law without committing malpractice if
Right.
I know all the facts before I start
Well-
the case, where I used to be able to sort out the facts as we do the case
Yep.
because it was so simple before.
It was. Well, I never felt it was simple, but at least it was somewhat predictable. You
Correct.
could potentially run into a thing that
Correct.
would cost you 30 days or here and there. You may not remember this, and we'll leave the names out because they very well may be watching, and I don't want to put anybody on blast. But I had a client who had started down a process on their own and was 5 months into that process. And then they came to me because the tenant was, frankly, a professional, knew exactly what
Right.
they were doing. And I'm like, well, this is a disaster. You
Right.
got to call Barry's office. Ultimately, the timing of it was such that there wasn't enough time to do it, but they ended up getting in front of the commissioner, and as suspected, the
Case
paperwork
dis-
wasn't correct. It got dismissed, and they're starting the process all over again, and they lost 5.5, 6 months
Correct.
to start over again. And that's gonna be a 1-year eviction.
Correct.
And half of that 1 year is because, frankly, they didn't call you in the very beginning.
And that's
So-
the thing that, it's preventative almost in nature now. Like I said at the beginning, we got to prove our case before we even start
Yep.
on the paperwork.
Yep.
And if the paperwork's not right, you're going to end up doing it over.
Yep.
Sometimes I've subbed in on cases, and and they come to me after they've done it, just like this, and I tell them, you're going to lose.
Right.
The only other alternative is we can go to court, and I can try to work out a settlement.
Right.
But it's not going to be a good settlement, but it might save you 5 months.
Yeah, well,
you
keep
may
fingers crossed you get lucky.
Yeah,
Maybe.
But that doesn't always happen.
Doesn't always happen.
No. And
Craziness, my friend. Here we are. How much longer are you going to do this?
I don't know. I have a daughter that passed the bar and everything, and she decided for some reason she wanted to be a law professor instead of doing a UD attorney. I can't understand that.
Probably she probably went to dinner with you one day and
No,
said,
she
"Geez,
worked for
Dad."
me since she was about 6 years old.
So that was enough. So she saw it. She saw it firsthand and said, "I'll be a professor."
But the other thing was when she went to law school, because what people don't realize, the unlawful detainer seems simple, but it involves evidence. It involves civil procedure.
So
it
it's a
involves
legal
criminal.
case.
Well, besides that, it involves almost constitutional law. It involves almost every subject in law that you learn in law school. It
Right.
doesn't sound like it, but there's wills and trust issues all the time.
Right.
There's probate issues all the time. There's contract issues in it. There's real property issues in it. So she went to law school and she was valedictorian of her class. But I felt like, she did an excellent job and everything, but I felt like it was almost cheating because she knew how to, she knew everything before she went to school.
She knew it all.
She knew it all.
Well, there you
And
go.
that's the thing with this, that it's so sad that it's so complicated, and it shouldn't be.
Right.
You know.
Well, welcome to California.
Welcome to California.
Right. Barry, my friend, I
Thank you.
appreciate you again. Okay, so for those of you that are watching this, we're going to get this video out before our 2024 market forecast, which is May 29th. It's coming up, so this will just be hitting, I'll get it onto my site here a couple days before that. But it's entirely possible that you might be watching this video not in 2024, maybe at the end of 2024 or 2025, because I also put this on our Cobalt Property Management website. And whenever I've got a new landlord thinking about getting into the landlord business, like, I want you to go spend 45 minutes and watch this video with Barry. If you can make it through the end of that and you still want to be a landlord, come see me and we'll take care of you. So, at any rate, thank you once again, Barry.
Thank you. It's a
all right,
pleasure
my
as
friend.
always.
All right.
Thank you.
All right, and we will see you soon.